This just dropped and it changes the rules for every gun owner in America overnight. By an 8-1 vote, the Supreme Court just handed down a ruling that shifts the entire landscape of the Second Amendment and opens up a massive new legal battle. If you think this is just about one specific case or one person, you are missing the bigger picture that could hit you next. This decision changes how the government can take away your rights before you are ever convicted of a crime. It touches on everything from traffic stops to home defense, and even how you store your firearms. Most people are looking at the headlines and seeing a simple win or loss, but the real story is hidden in the fine print. We are talking about the case of United States v. Rahimi, which the Supreme Court decided in June of 2024. The court ruled that the government can temporarily take away gun rights from people under specific restraining orders. Chief Justice John Roberts wrote the opinion, and only Justice Clarence Thomas stood on the other side. On the surface, it looks like a narrow ruling about a very specific type of person who most people don't like. But the way the court got there is going to affect every single gun law currently being challenged in lower courts. This isn't just about restraining orders. It is about the new test for all of your constitutional rights. Many people are getting this wrong already because they think the court just undid the big Bruin win from a few years ago. They think the Second Amendment just took a massive hit, and that the government now has a green light to pass whatever they want. That is not the full story, and in some ways what the court did here is even more complicated than that. In this video, we are going to break down what actually happened, why the 8-1 vote is so misleading, and what this means for your safety. I will show you the hidden traps in this ruling that most news outlets are completely ignoring right now. You need to understand this before a simple misunderstanding turns into a life-altering legal nightmare. If you are the kind of person who wants the real truth about your rights without the political spin, you need to hit subscribe right now. Things are moving faster than ever in the courts, and staying informed is the only way to stay ahead of the curve. We track these cases every single day so you don't have to spend hours reading boring legal papers just to know if you're still protected. This channel is for the serious, informed citizen who knows that knowledge is the best defense for your freedom and your family. Join our community today so you never get caught off guard by a sudden change in the law. To understand why this Rahimi ruling is such a big deal, we have to look at the history of how the Supreme Court treats guns. For a long time, the government used a balancing test to decide if a gun law was okay or not. They would basically say that even if a law hurt your rights, it was fine if it made the public feel safer. That changed with the Bruin case in 2022, where the court said the government must prove a law fits our history. They said if a law doesn't have a twin from the time the Constitution was written, it is probably unconstitutional. That was a huge win for gun owners because it threw out hundreds of modern restrictive laws across the country. But the Rahimi case was the first big test of that new historical rule, and it was a messy one to start with. Zaki Rahimi was not a hero for the Second Amendment. He was a man involved in several shootings and under a domestic violence order. The government argued that because he was dangerous, they could take his guns away without violating the Second Amendment. The lower courts actually agreed with Rahimi at first, saying there was no historical law exactly like the one used against him. This put the Supreme Court in a tough spot: either follow their own rules strictly or find a way to make an exception. They chose to find an exception, and that is where the new battle begins for all of us. The court decided 8-1 that the government can disarm people who a judge finds pose a credible threat to others. They didn't say the government needs a direct twin law from the 1700s anymore. They just need a neighbor law. Think of it like this. If you want to build a house today, the court used to say it had to look exactly like a house from 1791. Now they are saying it just needs to have the same kind of foundation and follow the same general spirit. This might sound like a small change, but in the legal world, it is like moving the goalposts in the middle of a game. It gives the government a lot more room to argue that their modern gun bans are similar enough to old laws. I want to know what you think about this 8-1 decision and the idea of similar laws instead of exact ones. Does this make you feel like the Bruin victory is being watered down, or do you think the court is just being practical? Some people say this is a common sense way to keep guns out of the wrong hands, while others see it as a dangerous, slippery slope. Drop a comment below and let me know if you trust the courts to decide who is dangerous without a criminal conviction. Your comments help us show the world that gun owners are thinking deeply about these complex issues. Now here is why the headline alone is so misleading for the average person watching this at home. Many news sites are reporting this as a total defeat for the Second Amendment, but that is simply not true. The court was very careful to say that this ruling is narrow and only applies to people who have had a specific hearing. They did not give the government the power to just declare anyone dangerous and take their firearms away on a whim. In fact, Justice Thomas's lone dissent warned that this ruling could be used to chip away at the rights of law-abiding citizens. He argued that if we don't stick to the strict historical record, the government will eventually find a way to ban everything. The part that people are missing is that the court did not bring back the old balancing test that we all hated. They still said the government has to look at history, even if they can be a bit more flexible with the comparisons. This means the fight isn't over, it has just moved to a different part of the battlefield. We are now going to see years of arguments about what counts as a similar law from the founding era. Every state with a high-capacity magazine ban or an assault weapon ban is going to try to use this ruling to save their laws. They will try to find any old law about dangerous weapons and claim it is the same thing as what they have now. Here's what this means for you in your daily life as a gun owner or someone who cares about safety. This ruling confirms that your rights can be paused or taken away even if you haven't been convicted of a felony. A felony is a serious crime that usually carries a prison sentence, and it has long been a reason for losing gun rights. But now, a civil restraining order, which doesn't require the same level of proof as a criminal trial, can be enough to disarm you. This means if you find yourself in a messy divorce or a heated dispute, your Second Amendment rights are on the line early. You could be forced to turn over your property before you ever get to tell your full story to a jury. Think about a traffic stop where an officer sees a firearm and runs your name through a database. If there is even a temporary order against you that you didn't know about, you could be facing immediate arrest and seizure. Before this ruling, there was a strong argument that these kinds of orders were unconstitutional because they didn't have a clear historical match. Now that argument is much weaker, and the police have more confidence in enforcing these types of dispossession laws. You have to be more careful than ever about your legal standing and any paperwork that involves your name in the courts. A small mistake in a civil case can now lead to a permanent loss of your right to self-defense. This is where this gets serious for people who have never been in trouble with the law a day in their lives. The dangerousness standard is something that can be stretched by aggressive prosecutors and anti-gun politicians. If they can convince a judge that a certain group of people is dangerous, they might try to use this Rahimi ruling to disarm them. We are already seeing some states try to label anyone who carries in public as a threat to the peace. This ruling gives those states a tiny crack in the door to try and push those radical ideas through the legal system. It makes the definition of law-abiding much more fragile than it was just a few months ago. The bigger issue here is the trap that many gun owners might fall into if they aren't paying attention. Some people might think that as long as they aren't bad guys like Rahimi, they have nothing to worry about. But the law doesn't always distinguish between a bad actor and a good person caught in a bad situation. This is where people get burned by assuming the system will always see their side of the story. If the government can bypass the strict historical test for one person, they will eventually try to do it for everyone. This is why we have to care about the cases involving bad people, because the rules set there apply to us too. There is a hidden consequence coming next that almost no one is talking about yet regarding red flag laws. Red flag laws allow the government to take guns from people who are reported as a danger to themselves or others. Many of these laws don't give the person a chance to defend themselves in court before the guns are taken. After this 8-1 ruling, proponents of red flag laws are feeling very confident that their laws will now survive in court. They will argue that if the court allowed Rahimi to be disarmed, they can allow anyone flagged by a neighbor or relative to be disarmed too. This is where the next big fight starts, and it is going to happen in almost every state in the country. If you want to stay ahead of these red flag battles and see the secret ways they are trying to expand these laws, you have to stay subscribed. We are already digging into the new state bills that were written specifically to take advantage of this Supreme Court ruling. There is a lot happening behind the scenes that the mainstream media is too lazy to cover or too biased to tell you. By staying with us, you get the early warnings you need to protect your rights and your property before the laws go into effect. We don't just tell you what happened, we tell you what is coming next so you can be prepared. Let's look at a scenario that could happen to a normal person, like a concealed carrier traveling across state lines. Imagine you are driving through a state that has very strict laws and you get pulled over for a broken taillight. The officer asks if you have any weapons, and you honestly say yes and show your permit from your home state. But this state has a new law that says anyone with a history of conflict cannot carry, and they define that very broadly. They use the Rahimi neighbor law logic to say their new restriction is just like an old 18th century law about a fray or fighting. Suddenly, your legal carry becomes a criminal act because the state stretched the definition of similar laws to fit their agenda. Think about another situation involving a first-time gun owner who buys a firearm for home defense. You go through the background check, wait the required time, and bring your new tool home to keep your family safe. But then, a neighbor who doesn't like the sight of a gun case calls the police and claims you were acting erratically. Under a red flag law emboldened by the Rahimi ruling, the police could show up at your door that night to take your firearm. You haven't committed a crime, you haven't been arrested, and you haven't seen a judge, but your rights are gone. This is the practical problem of moving away from exact historical matches to similar spirits of the law. Or consider a parent who is going through a tough custody battle and their ex-partner files for a temporary restraining order just to get an edge in court. In many places, these orders are granted automatically until a hearing can be held a few weeks later. Because of the Supreme Court ruling, that temporary piece of paper can now be used to strip you of your Second Amendment rights immediately. You might be the most responsible gun owner in the world, but the law now treats you the same as a violent criminal during that window. The difference between protected in theory and risky in real life has never been thinner than it is right now. This is why you must understand the procedures in your local area and have a plan for legal defense. Now, I want to cut through the noise and correct some major myths I am seeing all over social media about this case. The first myth is that the Rahimi ruling means the Bruin history and tradition test is officially dead. This is completely false, and even the liberal justices acknowledge that the historical test is still the law of the land. The court didn't throw out history, they just clarified how to use it when a modern problem doesn't have a perfect historical twin. If a lawyer tells you that history doesn't matter anymore, they are giving you bad information that could get you in trouble. History is still the primary shield we have against government overreach, and we have to keep using it. The second myth is that this ruling only affects dangerous people who are already breaking the law. As we discussed with the scenarios, the definition of who is dangerous is the very thing that is now up for grabs. This ruling opens the door for dangerousness to be defined by politics rather than by actual criminal behavior. It is a tool that can be used against anyone the government decides is a problem, which is why it is so risky. Don't fall for the trap of thinking that because you are a good guy, these changes don't apply to you. The law is a set of rules for everyone, and when the rules get blurry, everyone is at a higher risk of being treated unfairly. The third myth is that Justice Thomas was wrong to dissent alone, and that the other 8 justices have fixed the Second Amendment. Justice Thomas wasn't being stubborn, he was being consistent with the rule the court itself created 2 years ago. He predicted exactly how anti-gun states would use this flexibility to bring back all the bans that were recently struck down. If we look at the history of the court, the lone dissenter is often the one who ends up being right decades later. His warning is a roadmap for future lawsuits that will try to rein in the government's new power to label people as dangerous. We should be paying very close attention to his words, because they will be the foundation of the next big legal fight. This is like a speed limit on a highway where the signs are suddenly changed from 55 mph to safe speed. When the sign said 55, everyone knew exactly what the rule was and how to follow it. But when the rule becomes safe speed, it is up to the individual officer to decide if you are going too fast. One officer might think 50 is safe, while another might write you a ticket for going 40 in the rain. This Rahimi ruling turned a clear 55 mph rule into a safe speed rule for our constitutional rights. It creates uncertainty, and uncertainty is where the government always finds a way to take more power from the people. This is not just about legal theory, it is about the dignity of being a citizen who is trusted until proven otherwise. The American system is supposed to be built on the idea that you are innocent until a jury says you are guilty, but these prophylactic or preventative laws are trying to flip that on its head by punishing you before a crime happens. The court's ruling in Rahimi says that the government's interest in preventing future violence can sometimes outweigh your current rights. That is a heavy idea that should make everyone, not just gun owners, a little bit nervous about where we are headed. If they can do this with the Second Amendment, what is stopping them from doing it with the First or the Fourth? We have to remember that one legal event can trigger 1,000 more in the lower courts. Right now, judges all over the country are looking at this Rahimi decision and trying to figure out what to do with their own cases. Some will use it to uphold gun bans, while others will try to keep the Bruin protection strong. This means we are entering a period of massive confusion where the law might be different from one town to the next. You could be perfectly legal in one county and a criminal in the next because 2 different judges interpreted similarity in different ways. This is the new battle that the headline was talking about, and it is going to be messy and long. This is where the future of the Second Amendment is going to be decided, in the boring small-town courtrooms where these neighbor laws are debated. We have to be ready to support the legal groups that are fighting these battles on the ground. It is no longer enough to just wait for the Supreme Court to hand down a big ruling every few years. We have to be active in our states and our communities to make sure the dangerousness standard isn't used as a weapon against us. This is a call to action for everyone who believes that rights are not something the government allows us to have. Rights are something we are born with, and we have to defend them every single day. When you think about the human meaning of this issue, it really comes down to the pressure of being a gun owner today. You are expected to know every new court ruling, every state law, and every local ordinance just to stay out of jail. It is a lot of weight to carry, especially when the goalposts are moving like they did in this 8-to-1 case. But you don't have to carry that weight alone, and you don't have to be a legal expert to stay safe. By sticking together and sharing what we know, we can navigate this new landscape without losing our heads or our freedom. That is the goal of everything we do here on this channel. The part that should worry you is how fast the consensus shifted among the justices. Seeing 8 of them join together to soften the Bruin rule shows that even the Supreme Court feels the pressure of public opinion. It shows that the originalist movement, the idea that we must follow the original meaning of the Constitution, is under internal stress. This means we can't just take the current court for granted and assume they will always be on the side of the Second Amendment. We have to keep the pressure on and keep reminding the legal system that the Bill of Rights is not a second-class set of rules. We have to be just as loud and just as consistent as the people who want to see these rights disappear. Here is the bottom line as we look at the wreckage of this 8-1 decision. The court didn't destroy our rights, but they did make the defense of them much more complicated. They traded a clear, bright-line rule for a fuzzy, similar enough standard that will be abused by anti-gun politicians. This means the era of easy wins in the courts is over, and the era of the long grind has begun. We are going to have to fight for every inch of ground from here on out. But gun owners are some of the most resilient people in the country, and we have faced much worse than this before. As we bring all of this together, I want you to remember 3 things from today's breakdown. First, the Supreme Court ruled 8-1 in Rahimi that the government can disarm people under restraining orders if they are found to be a credible threat. Second, this ruling changes the historical test from needing an exact twin law to just needing a similar neighbor law. Third, this is going to lead to a massive wave of new court battles over red flag laws, magazine bans, and assault weapon restrictions. You are now in a new legal environment where the definition of dangerous is the most important word in the dictionary. This is the reality we are living in, and we have to face it with clear eyes. Why does this matter in the long term for you and your family? It matters because the Second Amendment is the final guardrail for all of our other liberties. If the government can find a way to flexibly interpret how they disarm the people, they can find a way to do anything. Protecting your right to keep and bear arms is about more than just the firearms themselves. It is about the balance of power between the people and the state. When that balance shifts, everyone is less safe, and the future becomes much more uncertain for the next generation. We owe it to our kids to make sure they inherit a country where their rights are solid, not flexible. You should leave this video feeling more alert and more prepared, but not afraid. Fear is what the other side wants you to feel so that you will just give up and stop fighting. But being informed gives you a different kind of energy, a steady, calm resolve to keep moving forward. You know the law, you know the risks, and you know how to stay on the right side of the line while still standing your ground. That is what being a responsible gun owner is all about in the 21st century. We are the ones who hold the line, and we do it by being the smartest people in the room. This is a mission for all of us to stay sharp and stay connected as the legal world continues to shift. If you want to be part of a community that refuses to stay uninformed and refuses to let our rights be chipped away in silence, you belong here. Hit subscribe and join us for the long haul because this 8-1 ruling is just the opening bell of a much larger fight. Drop a comment with the phrase, "Hold the line," so I know who is with us and ready for what comes next. Your engagement helps us reach more people and build a bigger, stronger voice for the Second Amendment. Thank you for watching and stay safe out there.